like 2-3 minutes in on a Saturday evening. I'm Srinjoy, the convener of Law and Technology Society at NLSIU, and I would like to welcome all of you to this insightful discussion. As you all must already be aware of, the Committee on Digital Competition Law has recently submitted its report and has prepared a draft bill on the digital competition law. The potential law has been the subject of multiple debates for its potential effect on competition and innovation. And it is in this backdrop that this panel discussion becomes all the more important. And for those at NLS, I understand that the Wi-Fi is not working, so many people couldn't join. But thank you all for joining in again. So without wasting much time, I'll briefly introduce the panelist and the moderator, and then give it to the to Kazim sir, the moderator, to start the discussion. In the panel, we first have Ms. Deeksha Manchanda, who is a partner in the competition law practice at Chandhiok and Mahajan. She specializes in advising clients on all aspects of competition law. Her practice area spans across various sections, particularly in the technology, auto components, and pharmaceutical space, where she has advised and represented clients on complex and novel competition law issues. She has represented leading technology companies such as Google before various forums and acted in India's only friend-related competition dispute. Up next, we have Dr. Tilottama Raychaudhuri, who is an associate professor at NUJS Kolkata and is a member of the Network of Competition Experts India. She is also the coordinator of the Center for Competition Law NUJS and works with the CCI in carrying out competition assessments of policies and legislation. Then we have Mr. Kashish Makkar, who is a gold medalist graduate of NLSIU and holds a first-class LLM from the University of Cambridge. He has experience of a wide range of competition litigation in India, ranging all across the spectrum from abuse of dominance and cartels to vertical agreements and merger control. Currently, he is working in the UK with the Competition Directorate of the Financial Conduct Authority. In this role, he is at the forefront of competition issues arising in the UK's financial services industry, from hardcore infringements to competition remedies arising from market studies. And finally, we have our moderator for the session, Mr. Kazim Rizvi, who is the founding director of The Dialogue, a public policy think tank based out of New Delhi, an important voice in India's tech policy ecosystem. Kazim works on the intersection of technology, policy, and society with a focus on evidence-based research and discourse. Thank you, sir, for agreeing to be our moderator. I think Tilottama ma'am has not been able to join or has left. I'll just quickly check with her. But in the meantime, Kazim sir, if you want to open the floor.
Thanks a lot, Shinjo. I hope I'm audible. People can hear me. Perfect. Great.
Yes, you are.
So thank you. Thanks a lot, NLS, for organizing this discussion on the digital competition bill. And it's a pleasure to be among such a distinguished set of panelists to discuss the bill, which was recently introduced a month ago and is currently in the consultation stage. So as we proceed, I think we'll spend probably the next 1.5 hours debating and discussing the bill. And what we've done is we will be dividing it into 4 different themes. The first theme will be around looking at the scope of the core digital services, right? And there are 9 core digital services which have been identified. So we'll be going through that. We will also be discussing the obligation of the SSDs. So the panelists will come in and try to sort of make us understand as to what is the criteria and how the obligation will sort of fare when it comes to different type of anti-competitive practices. We'll also be discussing the powers of the central government and the nature of ex-ante regulation. And over here, I will be sort of taking us in terms of the various aspects of the law. So of course, looking at what the UK is doing, what the EU is doing, capacity issues with CCI, also discussing the consultation process and possibly the thresholds as well, right? So we have a lot to sort of unpack. And I'd like to start the discussion. I think Tilottama is not here, but I think we can kickstart the discussion and get into the first theme, which is on the scope of the core digital services of the bill. So just to take you all through, there are a few core digital services that have been identified by the CCI. which includes online search engines, online social networking services, video sharing platform services, interpersonal communication services, operating systems, web browsers, cloud services, advertising services, and online intermediation services, right? So if there is an SSD which is dominant or is playing an important role in any of these CDS, any enterprise which is playing an important role, then it gets classified as an SSD. And these are the services which are being looked at from the point of competition harm. So I just want to sort of come in quickly on this itself and possibly ask Deeksha to just sort of kickstart the conversation. And Deeksha, I just want to sort of get your first-hand opinion and views on the CDS itself. And just want to understand basically, in your opinion, was there sufficient evidence which was collected and relevance for the selection of these core digital services with respect to the Indian market? So what are your early thoughts on this?
Thanks a lot, Kashish, and thanks to NLS for giving us this platform. I think this is such a watershed moment for competition law that it's really good to be talking more and more about it. But quickly taking up the question, core digital service really is the foundation, one of the foundations actually of any ex-ante law, because that will define the scope of applicability of the law. It doesn't apply to everyone, but it will apply to some entities within the core digital service, or who provide the core digital services rather. So it is a very important concept for creating this law, in the sense that if you've identified a problem, the core digital services should actually be a big part of that problem that you've identified for why you've introduced the law. Equally, the core digital services will determine, or your definition of core digital services will determine how effective and efficacious your law is. So it's a very critical element of an entire ex-ante regime. A very quick note on what I think has happened here. It's the CTCL's report is heavily influenced by what has been happening in other jurisdictions. And of all the other jurisdictions, I think the Brussels effect feels a lot stronger. So what we see is a sort of a structure which has been created by the Digital Markets Act in Europe, has been used and has influenced the structure of the law in India as well. So in Europe, you had 10. We have come up with a defined list of 9, which is all fine. I think the question for us to probably think about at this stage, when it is still a bill and not an act, is, and as you rightly pointed it out, Kazim, it's how have we defined these? Why these 9? I could pick up each one of them, and we could go through why we think it's a core digital service or not. But I think that is the job that ideally should have been done by the report which preceded the bill. And there is no discussion, unfortunately, in the report. You see peppered discussions about things that the CCI has examined. And from that, you can probably pick up and see why a particular core digital service has been identified. So for instance, they talk about having looked into WhatsApp, Amazon, Zomato, Swiggy, various services provided by Google, the Play Store, the search services. And I think from there, you can say that probably the thinking has been that these are the areas where there is risk, or we see higher degree of anti-competitive conduct. So let's put them into core digital services. But to me, it seems like, and if you go through the DMA as well, or you go through the reports that are being churned out across the globe about this issue, identification of core digital services is perhaps to identify critical elements of the digital ecosystem, which potentially could be subject to anti-competitive conduct. And that anti-competitive conduct, when seen upstream with their competitors and specifically downstream on both sides of the markets in which they operate, is going to have a lot of negative effect on the market, which negative effect regulators feel cannot be rectified after they have done a long inquiry and passed certain remedies. I think that broadly is the theoretical construct, various parts of the theoretical construct on which core digital services should be identified. I'm sure Tilottama and Kashish and you will have different views about it. It's probably a very, very basic approach to adopt, but that seems like some of the likely elements that you've put into the basket of considering what are core digital services. I unfortunately don't see that, as I said, in the CDCL report. So we have very little to go by on why these services have been identified, except that it's influenced by Brussels.
Thank you, Deeksha. And I think if I may just add to this, I do feel that barring a few, there's little evidence to suggest whether there is potential anti-competitive conduct when it comes to the core digital services that have been identified with respect to the Indian market. And the same goes for the lack of market studies itself by the CCI, right? So I think that's something which has been highlighted in many discussions. In cases where there is already going on investigation or investigation that has concluded, it makes sense to add those services as CDS. But what about CDS that have no history of either an investigation or a market study by CCI? Where do we go there? I'll come to Dr. Tilottama on that point, but I want to go to Kashish first. And Kashish, just sort of wanted to take your opinions from where Deeksha left. And what's your thoughts on this? And also, what's your thought on merger control not being part of this?
So I think I can cover merger control in the next theme, but let me just begin here. And first of all, thank everyone for, thank you, NLS, for organizing this. And it's obviously great to be back at the alma mater and speaking about an issue that you're passionate about. With respect to the identification of the core digital services, I sort of agree with Diksha that there's not a lot of thought that you can see that's happening in the report as to where you have picked up a lot of the definitions from, or where you have identified why these are relevant for you. But I think we should also not be overtly critical of this, because you have to start somewhere. And if you have to start somewhere, you would have to pick certain frameworks that exist in the world. And due to the nature of tech regulations, nature of tech world and how it's advancing, most of the examples are widely applicable. I am one of the biggest critiques of India blindly following other jurisdictions in applying its laws, like CA 98 or CA 2002. Our Competition Act 2002 came because everyone just was implementing a Competition Act. Now we are coming up with the Digital Competitions Act again because, okay, EU has implemented a DMA and then other countries are also going about it. So why should India not have it? I understand, and I'm a critique of that, but I do think nitpicking whether there could be merit in, for example, how these are actually interpreted and applied, because there's not a lot of decisional practice around it. But I would think these are still helpful because they do provide a starting point, and they provide you a point where you can at least start building a framework, and you need these for regulations. So I would not be too overtly critical of it.
Thanks, Kashish. Tilottama, I would just like to come to you. What's your take on this? Do you agree with Kashish's point that this is somewhere we have to start somewhere, right? And possibly in the future, we could look at potential anti-competitive conducts in some of those services where there is lack of evidence. But just talking from a framework's point of view, and also when a law is drafted or a bill is drafted, it requires evidence, and it's based on evidence and studies and research, which informs the bill. Do you think in this case there was enough evidence collected, or do you think this is some sort of a starting point and we can improve as we go from here? So over to you.
Hello, everyone. And thank you, NLS, for inviting me and having us engage in this discussion. So, to cut it short over here is that I agree with the fact that, when I was looking through the report, one thing which seemed absent was an analysis of why these have been designated as core digital services. But there was work done on, how other legislations were reviewed, referred to. So I kind of agree that this is a starting point in the sense that these are accepted as core platform services. in most jurisdictions of the world. And, there is, so in bits and pieces, we have defined it in the sense we do look at, like, for example, if we look at European law and we look at what these core platform services could be, uh, we like to look at those services for which you need to have a specific law to address these services. So I would say this, yes, this is a starting point, and I agree with Kashish in the sense that, we can't do nitpicking, but yes, a little more discussion on why these are core, even if, let's say, it was in the form of 2 paragraphs, that would be necessary. I agree with you. But let's see the way law goes, because again, these practices are nothing new, and though there is no consensus as to whether we should have ex post or ex ante regulation, there seem to be consensus on these practices being very important anti-competitive practices in the digital market. So we can start from there.
Just thanks a lot, Tilottama. So just a point on this, and I'll come to Deeksha on what could be the process. But and this is something which I also sort of want all panelists to sort of figure is, are the market realities in India similar to Europe, which demands or which necessitates such a categorization? I think that's also something which I would like the panelists to focus on. But Deeksha, over to you, and just going on from this point. So if you think that the process which was followed maybe was a fractured process, what could be, in your opinion, what are the parameters which should be taken into account when you identify CDS?
I think some of it I touched upon in the initial part of the discussion. I think it has to be how critical is the infrastructure that the CDS is providing. That definitely has to be the first part of it. And secondly, what you're really trying to address with all ex-ante, to the best of my understanding, is the fact that remediation is not easy once anti-competitive conduct has taken place. So it would again be focusing on that reality, that which are the ecosystems where market forces cannot act in a manner to remedy things once there has been regulatory intervention. So I think it would need to be, it is a largely, okay, let's put it this way. The theoretical framework has to be criticality of the ecosystem and your ability to remedy the ecosystem effectively with regulatory intervention. And then this has to be bolstered with empirical studies. So you really need to go out and see which are the critical ecosystems, how are they critical. For instance, if you take up something like a video sharing platform service, right? We've seen that market is fairly disruptive. Like, you had a TikTok go away and then you had people come in. Now on the counterpoint could be that the ones who came in were already established players, and TikTok went away because of some reason. But I think you will have to look at the general necessity of any entity within that ecosystem. So it is an exercise which will have some elements of empirical study involved on a theoretical base. I agree with both Kashish and Tilottama that what's happened in other jurisdictions, that can always be a starting base. It has to be like, if there's work happening elsewhere, there's no point of throwing it into the dustbin. But that work should then be considered in the context of each market. And we might come to a conclusion that, see, there really is no difference. Most of these markets are global in nature. But that exercise needs to happen for you to weed out any false positives, any errors in this process.
We'll come to you, Tilottama. So Kashish, I think, what's your take on the exclusion of merger control? What do you think of that? Is it because of existing amendment which were already brought in, so it made sense to not have it? But
Yeah,
would love to get your
I
thoughts.
mean, my initial view is that the parliamentary committee identified 10 anti-competitive practices that exist in the tech space. The 10th one was the merger of merger of tech companies, and that makes the players too big to control. And my particular focus here is on clear acquisitions, because clear acquisitions are the ones that generally cannot be caught by competition law because of either the de minimis thresholds, like the small target exemption that's available, and even with the deal value thresholds that have been introduced. And that was the reason that was provided in uh, the report, that the CDCL report, that we are not focusing on the 10th anti-competitive practice as a practice that needs to be regulated under the proposed Digital Competition Act, because the Competition Amendment 2023 already takes care of it, which is it proposes deal value thresholds. But not the that's not the ideal. Like, I mean, I would have liked, for example, the CDCL to have provided a more holistic approach to this issue, because deal value thresholds fair, they do try to capture acquisitions where there are like small companies that may be acquired by bigger companies. But I would still think, you have given a framework in the Digital Competition Act, right? What you have done is you have designated certain entities as systematic SSDs, basically the entities that have a good number of turnover, have global presence, then have a number of users in India. You have designated that particular entities as such. You have provided that framework. You have to also understand how those entities function. They function by acquiring small companies at very nascent stages, taking over that technology, and then becoming undefeatable again in that sphere, right? So, for example, I have this example in 2021 that happened when Google acquired for YouTube India-based startup called SimSim. I'm not sure if how many people know about it, but that acquisition was for 500 crores or something. The deal value thresholds wouldn't have caught it. That acquisition was supposed to that company that was acquired focused on like Chinese style marketing of influencers selling products via videos and people commenting and buying products, and that was the scope of the app. YouTube acquired it under its like business for Alphabet, and then that company was killed. It doesn't exist anymore. Now, your deal value thresholds would not catch it. It would be most likely exempt from because it's under 2,000 crores. But Alphabet will be a SSD. You will be regulating it for a number of core digital services and the anti-competitive practices that would permeate under those under those core digital services. But what is the primary mode that which Google, etc., use to expand and stay relevant and stay competitive and stay undefeatable? That there was no actual analysis in the report that I saw. Okay, you have said deal value thresholds would capture it. Would they? Because that's not what they do. Like for YouTube, it would be less than a month's revenue that they spent on SimSim to buy it. And then it got killed. So, I mean, that was my idea, that you have basically ruled out one anti-competitive practices, which is one of the major methods that bigger companies use to expand and build into these spaces. And you have said, oh, deal value thresholds capture it. We don't need to worry about that. But I would have liked the report to do a lot more on that, honestly. Yeah, that was my link to
So you think you think the 23 amendment is insufficient to deal with?
I mean, it's not bad. It's good. I'm not saying it's irrelevant. I'm saying you have created an infrastructure under this act, which is identifying SSDs. If you will be focusing so many resources on monitoring what they are up to, why leave one out?
Or maybe are they trying to be specific to what they want to regulate? I don't know. But Tilottama, what do you think? What's your take on this?
No, I was actually, I had raised my hand to say something on what Deeksha was saying because it suddenly struck me. So I'll just move back. Before that,
Yeah.
my take on this is, I agree with Kashish in the sense that if you had to do a comprehensive study of all the core digital services, it made sense to include this also. But I wouldn't want to speak more on this. I wanted to say on the absence of market studies and focusing on CCI orders, one thing I came across while looking at the standing committee recommendations, then this is that, even the cases the CCI has decided are only maybe directing for prima facie investigation. So we'd have no conclusive case law on this, very few. most of them. So while we don't have final orders in most of the cases, we also do not have adequate market studies. Having said that, we have taken the views of a number of stakeholders, industry associations, as well as companies. Also startups with India presence, like, there were arguments made by companies like Swiggy that is the environment suitable for encouraging startups. So I would say that, yes, we did need a little bit of time, but let's see, in the sense that we have nothing concrete to take from in, as far as the case laws go. That's what I'm trying to say in India.
Right. Fair enough. Before we move to the next theme, Deeksha, you had your hand raised, so if you wanted to come in quickly.
Yeah, I just wanted to come in on what Kashish said about merger. I've personally always been a little confused about how extensive the role of a competition regulator will be in cases of merger. And I think what really tested it was what the Parliamentary Standing Committee said, because they talked about it and then they said, okay, all of you come and tell us about it. And then there was nothing after that, right? It was a big question mark on what happens once we tell you about it. So I think that probably might have been a part of the reason why this did not really come through, because that what then was something maybe the CTCL couldn't arrive at a conclusion to. Though I would think that with the new act that they were coming out with, they had full ability to move away from the concept and the definition of combinations under Section 5 and just say that everything being done by people in this sector needs a notification, which is I think probably where Kashish was going, to which my problem often is that how do you assess it, right? It's vertical theories of harm, conglomerate theories, these all tend to be, and even actually in this case, there might be horizontal theories of harm arising. They tend to be so complicated, and especially when you're comparing them with acquisition of smaller companies where the focus of at times a lot of these startups is that we want to be acquired. We want to release the capital that has been put in, focus on something else. I think it's a very, very complicated commercial aspect. So I always find it very tricky to say that, it's killer acquisition. Like I know there is, the theory exists, but I think there is so much to be discussed in terms of what actually is a killer acquisition, because I think there'd be a very small parameter of things that we finally end up finding fall within killer acquisition, especially when we put it in context of, we put the regulatory power in context of shareholder rights, of rights of entrepreneurs to release capital.
Yeah, and just on that point itself, what do we, is there a defined definition of a killer acquisition, like globally? Is there something which we can sort of relate to the Indian market? Very quickly, Kashish, if you want to just come in and respond.
Yeah, I was just saying I sort of agree with Diksha. I mean, I would not say these are necessarily anti-competitive. Who knows if SimSim would have actually succeeded in the long term and become a competitor to Google's one of the like short services, YouTube Shorts, etc. I agree with you. We don't know if it's necessarily a competition issue that may arise, but I would have just liked the report to mention that one, to consider. Like, you can't just say because we did deal value thresholds, this is an ACP that we have rejected, does not exist. And the second one is the idea that you have set up an infrastructure, you have designated SSDs. I mean, if you are going to be monitoring them, it's not too much to also ask them any acquisition that you do probably should be notified. I don't know if that's justifiable. Probably we can then debate on vertical theories of harm if that policy is on the table. But I mean, those were my 2 points, and I agree with Diksha on the first
Fair
one.
enough. So I think quickly let's move to the second theme of the discussion, which is on the obligation of SSDs. So very quickly for everyone listening in, so the the report has come up with 6 obligations, principle-based obligations for SSDs, which includes trying and bundling, fair and transparent dealing, self-preferencing, data usage, restriction third-party apps, and anti-steering. And basically, what we're looking at over here is that the report specified these obligations, and SSDs have to report and comply, sort of develop compliance mechanisms to the Commission about the steps to meet the obligations outlined in the bill. So, if not for for the sake of the discussion, I will not explain each and every obligation which has been identified over here. Again, in the parliamentary committee report, there were 10 anti-competitive practices which were defined, and in the committee report, we have these 6 obligations which have been identified. So very quickly, I would like to come in and maybe we can go to Tilottama to start this conversation. So Tilottama, how do you sort of just compare this with the parliamentary committee reports, 10 ACPs? And how do you think these 6 obligations which the committee report has come up with, how will this impact the digital economy at large? So over to you.
So on reading, I mean, what I basically thought is, I'll take a minute because there are certain deeper problems which we need to look over here. Okay. The main problem which I feel is before you designate anything as an anti-competitive practice or an obligation is that the moment in the act you've designated it as an obligation, it becomes a presumption. You are under an obligation not to carry this on. Okay, so it's a presumption. Now,
Yep.
the deeper debate is whether at this stage we should have a presumption the way we do. We also have a choice of, let's say, following models like UK, where there are threshold levels, you report, and then it's up to the digital markets team or unit to decide whether you are in violation or not. In the sense, there isn't such a broad net cast as a presumption or an obligation, unlike the European law, where there is an obligation. Now, I think the problem which is very, very difficult to address, and this comes directly from the discussion on the theories of harm, is 3 very important things. The first is traditional antitrust law. We look at it from the perspective largely of consumer gain. And when there are price injuries, we regard price injuries as more seriously than non-price injuries. Now, when we look at the digital space, there are several non-price injuries happening where we can translate them into price injuries later. For example, all the debates about data, etc. So the first problem is that, we have traditionally been very cautious in kind of, like, for example, with tying and bundling, if somebody gets a complimentary service, do you immediately strike it down or do you impose a presumption that this is anti-competitive? It could have a lot of pro-competitive aspects. The second thing that strikes me would be, let's say, advertising. And that is something interesting I notice hasn't figured anywhere is the concept of, let's say, a dark pattern. There are a lot of discussions on various jurisdictions. The point I'm trying to make is we have always been very cautious in avoiding false positives. And that's been a problem with antitrust law. Now here, if we jump the gun to ex-ante and we reach false negatives, especially in a situation like this, it could be even more harmful. So how do we go about with this problem? So if you ask me, the definition of anti-competitive practices and also what we've looked at as obligations, I believe at this stage, we should not make it like a presumption. We should, in the sense that these should not be automatic obligations till we decide to weigh the pros and cons, because even within the obligation sets are very broad. The CCI, we have left it to the CCI to spell down the specific criteria. But till that is done, I believe that, it is casting a net which is very wide. And so this is what I feel.
Thanks, Tilottama. Interesting point there. Deeksha, what do you think in terms of, do you agree with Tilottama's point that should we just sort of have these 6 obligations ready and, there is a presumption that, okay, there will be anti-competitive practices and you sort of go ahead with it, or should it be on a case-by-case basis? Do you think a sort of a more bespoke obligation? Is that something which we should go towards? So what's your take on this?
A very confusing, difficult question to answer, actually, Kazim, because I think the minute you say bespoke obligations, that becomes more ideal from the perspective of attuning it to the business model of each company, understanding the technical infrastructure, and then designing something which doesn't disrupt that ecosystem in a way that it becomes invaluable to people. So I don't ask an advertising platform to do something which makes advertising impossible, right? But equally, anything which is bespoke in nature also means there's a lot of subjectivity with the regulator. And then I think comes the issue of, if it's a ex-ante law, are you delegating way too much to the regulator? So there's a concern of excessive delegation, which then perhaps leads to the question of, if bespoke is what you think is ideal, did you really need this law? Because eventually the manner of determination of something which is bespoke is going to be identical to the process that we currently have under the Competition Act. So that's a little piece about bespoke. I personally think the way the act is right now, we'll end up getting something very close to bespoke, actually. If you look at various sections read together, so you have section 7.5, which talks about elements that the CCI is supposed to take into account while designing the obligations to each SSD. And that has some very subjective factors like economic viability of operations, prevention of unlawful infringement of pre-existing intellectual property rights, prevention of fraud, cybersecurity. These are things which, as a practitioner, I know that any company which is claimed to have been abusing the act because of ABCD reason, these are typically the defenses that are taken up. So you're essentially picking up the process that you were doing under the Competition Act. You've now put it into a statute, and you'll be doing the same thing under the statute. So for me, the issue with the 6 anti-competitive practices was primarily, why do we think that these need to be regulated by ex-ante? For me, that was a larger question, but I think there's surrounding questions also. Is 6 enough? How have you identified these 6 and dropped out the other 3? For one, okay, they at least give some reasoning, right? For merger control, there's some reasoning. I think for the other 3, we didn't see any reasoning at all. Not to say include them or don't include them, but at least have some informed discussion around it. So I think there are those preliminary questions as well, but I think a larger foundational question is, if ACPs is what you're wanting to regulate, which you're already regulating under the Competition Act, and if the framework that you've come up with in this act is mirroring what you do under the Competition Act, why do you need it in the first place? I think for me, that's a bigger existential question about the DCA.
But is the current Competition Act doing enough is also a question, I think, worth asking. Deeksha,
counter question to that, Kazim, is, let's accept the fact that the current act is not doing enough. Let's go with that. The report has some reasons that they give on why they think it is not doing enough. One of the reasons they come up with is the fact that investigations take too long, right? Because of the way the act has been designed. Now we take a step back and maybe go back to the basics. What happens under the Competition Act? I file a complaint, CCI examines it and says there's a prima facie case, sends it for investigation. Investigation happens. In between, there might be some writ petitions, etc., filed by companies because they feel, oh, my rights are being impacted. Matter comes back to the CCI. CCI examine, passes an order, goes into appeal. Very, very, very broadly, what's happening here? You put in the law, and okay, just one step of when the investigation happens under the Competition Act, it's a 3-step part, right? What is the relevant market? Are you dominant? What is the abuse? Now, what is happening in this act? You've set out the regulations. I will tell you whether I'm dominant or not. you will examine my submissions, declare me to be dominant. So the dominance assessment of the inquiry is happening at a separate stage. Then I have to comply and I'll file a complaint. I'll file my report with you that this is my compliance report. On the basis of that compliance report, instead of now doing an investigation, you will do the same thing of an inquiry. But even before that, the Act requires you to set out separate conduct requirements under section clause 7.3. So which means once I've been designated, you will sit down with me and you will try and figure out how I have to comply with everything. So the things that you were doing after the DG investigation, you're now doing at this stage. So I don't think any of the time is going to get limited. Writ remedies will lie for everything, even now, because judicial review cannot be ruled out. So at every stage, if I feel I've been wrongly designated, anti-steering has been considered wrongly because you've not taken into account the security of the ecosystem, I'll file a writ petition. So what is it solving for?
And what about data? I mean, the internet relies on advertising, right? I mean, that's also something, just a sort of a standard point I wanted to bring in. But Kashish, want to come to you, and I think what Deeksha spoke about was also philosophically whether we need an ex-ante regulation or not. And I think we have a different theme for that. We'd love to get thoughts on this. But coming back to the obligations, Kashish, what do you think? What do we mean by monitoring of these obligations? How will it happen? Is it going to be effective? What's your take on this?
Definitely. I think 2 points. One is a good point, which I think DCA does well, is it has not blindly followed the other jurisdictions in designating how the enforcement and the monitoring of obligations is going to happen. It has not given a straight-jacketed formula in the legislation. These are the obligations you need to follow. No. Like, these regulations have to be adapted vis-a-vis each industry. They have to be formed taking into consideration different players, and that gives a middle ground in terms of you have some sort of bespoke and you also have some sort of legislation. That's not existing in any other jurisdiction. So I would think that's a good thing that the report recommends, and it reflects at least understanding of the Indian circumstances, the kind of industry needs, etc., and how the industry could engage, like as compared to legislation, because prescribing anything in legislation, going back to Deeksha's point, makes it a writ remedy, and then just everything is subject to so much more litigation. So that there is at least that thought process that I would appreciate the report to have like recommended. Bad, I know I've just given them props, but now there are certain issues as well with this, which is it's dependent so much on these obligations. You have defined these obligations, and then you have said the part that Diksha said, how will these obligations be monitored and enforced, right? You wanted to make an ex-ante process, but what you have done is you have made a law, and the enforcement of law is again exposed. You are supposed to find in like if someone is complied with investigations or not, come investigate, DG will prepare a report. I don't see an ex-ante like regulation happening in this case. What's happening is again a litigation process that will have lawyers from both sides involved, negotiating with the CCI whether we have actually infringed our obligations or not. And the key to these discussions is I don't know why the report did not see the Indian experience on merger control so far, which is you would have seen in mergers, the CCI is a bit hesitant to recommend behavioral remedies, right? You generally prefer structural remedies. Why do you not prefer behavioral remedies? Because who will be monitoring it? It's too difficult, and you will give a field day to consultants, right? The same thing you are recommending now, you're proposing obligations, and measurement of that is not within the like I don't see CCI overlooking 15-20 corporations on each of the obligations and how they're compliant, it defining forms on how these particular obligations that were prescribed were met. What you're creating is so much scope for consultants to interpret these regulations, how they are met. I'm not even saying lawyers would step in later. This is like just consultants thinking about how these obligations have been met from business standpoint. And that's just too much that would be left at the end of the CCI to monitor if No, I don't know if I have a solution to this, honestly. I don't know how an ex-ante like monitoring process would look like if you were to not prescribe such obligations, if you were to discount the role of consultants, if you were to not have this. I don't know that. But that then goes back to the question of, okay, then why did you even need this process if you are not sure if you have the capabilities for it? Isn't a better process making the industry sit together with you as a regulator and then thinking about what works for them, what doesn't work for them? And probably in that case, I mean, bespoke could be an answer. I think, Kazim, you're on mute.
Yeah, sorry. Tilottama, what do you think? Just picking up from Kashif's point, do you think it's the CCS trying to do too much? I mean, if you look at these 6 obligations, I think it's a fair point, right? How will you monitor, when it comes to the SSDs and they're taking the right steps, in order to sort of make sure that they're not tying and bundling or, self-referencing or restricting third-party apps, or whatever that may be. But also, what's the experience in Europe? If you could also just come in, I don't know if you'd be able to, but would love to get some thoughts on that because DMA has been in place for a while. So maybe you or someone else could come in. But Tilottama, just sort of taking in from where Kashish left.
So, I mean, yeah, I agree that, in the sense that a lot of burden has been put on the CCI, and we are already a little skeptical about the constraints. Like CCI already has capacity constraints and monitoring of so much. Also, I'm not really very clear. I have to agree with the other panelists on how the monitoring would be done. Like self-reporting is one thing, review is one thing, but monitoring, and that too, I mean, if you have a look at the draft bill and everything, too much has been given to the CCI. Too much, like framing regulations for everything, expanding on the scope and the meanings of things, then the overall monitoring. Now, coming straight to Europe, it is too soon to say. It is too soon to say. Like you have jurisdictions like Germany who are working hard and there are cases decided which are proactive. But then effect of the DMA, it's still, and there is no general consensus even in Europe. So
Right.
to comment on the working of the DMA, I would say that, it would still take us, it's so new, we have to give it a few years to see how the monitoring is going. And then we can come up with answers to this. Regarding India, I would say, yes, it is a starting point and a lot of it is a little, unclear, wide, we can say that. Yeah.
Fair enough. I think we don't have any comments. Deeksha? Yeah, you have hand raised very
Well,
quickly.
just quickly coming in on the Europe piece, I agree with Tilottama. It's too soon to say, but
Don't
I
have
think
evidence.
whatever little we can, look at the European experience and think about it is one, we don't have very litigious companies and rush to courts in Europe as much as they have in India. Like the amount of rich jurisdiction we do in India is remarkable, right? Even from coming from that place where European companies don't keep rushing to court all the time, we saw challenges against designations. TikTok did challenge their designation, got rejected rather quickly, but it was challenged. So we know that the designation mechanism itself is going to be a hurdle for the commission. It won't be a happy process. There'll be some companies who know they can't, obviously we are designated, but the others who will try and contest it. And then is the process of setting out or defining the obligations itself. The DMA has similarly worded obligations, many more compared to the 6 that we have. And there were about 2.5 years, or maybe even more, maybe Kashish has some visibility on it, of discussions with industries and stakeholders, which were open discussions. So, you and I could join in. And there you could see the lack of clarity that was emerging on each of these. Like nobody knew what was required to be done under some of those requirements. I attended one on their FRAND obligation, and really it was all over the place. Like you could see that nobody really knew how to deal with it. But then there was very, very dedicated discussions, I believe, with companies, from whatever we've read, that companies had discussions with the European regulator to come out with their compliance plans. And then what we saw after that was recently, I think about 2 weeks ago, we have investigations initiated against four of them, four of the gatekeepers for not complying fully with the requirements under the DMA. So I think it's not self-executing. There was a word that was used on and on when discussions on ex-ante started, that we want a self-executing mechanism. What we do know from the European experience is that ex-ante is not self-executing. So I think that probably is what we can take away from there. And the second thing to take away is that it's a very collaborative process. It cannot be done in isolation by the CCI. It will really need a lot of the industry and the CCI to come in together and to come in with a lot of trust with each other. Very constructive, trustworthy discussions will need to happen for us to take any of this anywhere.
Self-reporting. Kashish,
Yeah,
any
I won't
sort of
take a
final
I won't take a
points?
lot of time. Yeah, I would just say that even I mean I understand why we can't draw a lot from the EU yet, but I would just say you don't even need to go that far. You had merger control, which was a flavor of ex ante. We know CCI did not was always hesitant about behavioral remedies, right? And there was a reason, because monitoring is always an issue. Now, how you have a regulator that's telling you that, why would you still recommend
Yeah.
something like that? If you would at least build capabilities for it, then is what then I would say. And second, on I would just add a lot to Diksha's point and support it so much so that it ends up echoing probably with somewhere, that the writ jurisdiction is actually very notorious. It's not even limited to, okay, for example, I have been designated as an entity, then I would end up appealing it in a writ court. Even I have been part of litigations where a RFI issued and its scope has been subject to writ. And that RFI scope ends up being litigated for 4 to 5 years, and a DG investigation goes on hold. So I wouldn't know how then, if you are to approach in a top-down manner in this case, how that would uh, so I'm not sure if the audience would know about RFIs. Um, Probably Kazim would can explain, or I can just explain. RFIs are initial requests that a commission makes uh, before the party, for the parties who are under its investigations, to get information on what they have been up to. And even that request for information and its scope gets challenged all
Gets
the time.
challenged, yeah.
Yeah.
So it's gonna entertain a lot of litigations, is where I can see. So good news for lawyers and budding lawyers at NLS. Please take up digital competition bill. Get ready to join Deeksha's team, or maybe Kashif's team, or other law firms as well, because there will be series of litigations. Corporate advisory, of course, will be part of that as well. So, and definitely when it comes to lack of evidence from Europe, that takes us to the sort of larger philosophical questions, whether this bill was required at this stage, or whether there was merit to wait for a few years and then come up with something like this. But I think those are all moot points. Kashish, you want to say something very quickly?
Kazim, just want to add there, sorry for breaking in again, but I think it's fine that the mistakes are getting committed for the first time in India, and we are not following the EU, and it's learning from there. It's time that India also sets standards for laws. So I mean, that's also I mean, I understand there could be so many issues around it, but to wait for the EU experience and then implement it is also probably not the right thing. So that's also a point that we need to recognize.
Just a matter of evidence collection, I think, just a matter of learnings, because I think just taking a different approach here, if we look at the data protection regulations, for example, we took time, and the final law which was enacted was quite different from the EU GDPR, right? It sort of followed more of a, people say it's sort of similar to a Singaporean approach, but it's still more Indian in terms of the way the bill has come up and being enacted, because I think the Indian lawmakers realized that the GDPR was way too restrictive on businesses. So maybe it requires merit. There is merit to say, okay, let's wait and see how a similar regulation is playing out. But I think again, the market realities are very different. So what works for Europe may also not work for India, right? I think that's something which we also go into the final theme of the discussion. But I want to move to the third theme, which is power to the central government. And there are certain powers which the central government has within the bill. So they can exempt an enterprise if it's in the interest of state security, public interest, treaty obligations, or sovereign function. It can issue directions on questions of policy for the Commission. It can also supersede the CCI for up to 6 months if it believes that there are uncontrollable circumstances, persistent non-compliance with these directives or necessary in the public interest. It can seek recommendation. It can also make rules to carry out the provision of the DCB, and it can notify and amend schedules as well. So I think what we'll do is spend maybe 5 to 7 minutes on this. And Tilottama, I want to come to you, and I'm going to ask everybody the same question: are these exceptions too broad? Do you think the central government has too much power when it comes to the bill? So over to you, Tilottama.
There are some features unique to our country, which has just been discussed in the sense this, if I put it this way, the problem with the writ jurisdiction, let's say, where we are prone to many challenges, which obviously, which have been faced in the past. Now, coming to laws in our country, this overriding, this authority of the central government, it's not new. It's there in many other laws. Now, so per se, this is something which we may have to deal with. It was there in the Competition Act, the Act, it's also there now. So there's nothing new in this, but there's just one thing I have to say is that if we look at actual cases where the central government has intervened in so many years of the law, there have been very few cases. One thing which struck us, particularly during the COVID-19 crisis, was there was a time when the central government may have needed to make exemptions, but there was nothing done. So my question is deeper. It's okay that we have this provision in the law, like we have in other laws of the country, but what has the central government really done about it? I have noticed a distinct absence in the COVID period, where in periods of crisis, certain systematic exemptions were required, and the CCI had given a very generally worded advisory. This was different from other countries, maybe where specific exemptions were granted. So this is my take on it. I don't see this. I really don't see any problem with having this overriding provision because it has been exercised very, very sparingly, in my opinion.
Fair enough. I think that's a very straightforward answer. Deeksha, would you agree?
Yeah, I think these are fairly boilerplate.
Yeah.
Can the validities of these be challenged? I'm sure there are grounds to challenge. And I'm sure that even if we don't challenge these, then any untoward action by the government on the basis of these can be challenged. Could we have a law without these, where the government does not have these overriding powers over a regulator? I think yes. For superseding, there are certain very specified circumstances within which it has to be done. The power to exemption is not that well defined. There are concerns in other statutes where such powers of exemption, they raise bigger issues. Insofar as the Competition Act is concerned, the worst we've seen the power of exemption being used is that they exempted public sector oil companies from the requirement to notify under Section 5 of the Act, because I think at that point in time, ONGC was doing some divestment, if I'm right, if memory serves me correctly. So I think we've seen instances where if they don't want a PSU to actually be subject to the rigors of something like a combination requirement, they have used these notifications. Is it ideal? No. But I guess, as Tilottama was saying, unless somebody really goes ahead and challenges the validities of these, we probably have to live with these provisions.
It's quite different from the exemptions under the Data Protection Act for sure. So
yeah, I think theirs are a lot concerning. Correct.
Yeah. Kashish, any additional points here?
I think not much more from what Tilottama and Deeksha have already said. I think this is just part of the trial and error phase that this bill will see upon its enactment. So probably the central government would need powers to do it. I don't have a particular strong agreement or disagreement with it.
Fair enough. And I think we have a few questions coming in. So I think what we'll do is we'll sort of finish the entire discussion and then we'll take those questions. I think there are a couple of comments as well. So we'll take those as well. But final theme, I think we have around 15-20 minutes before we break for questions and open the floor. And this is on the general nature of ex-ante regulations. Interestingly, a lot of this has already been covered and discussed by the panelists, but I still want to sort of get into the meat of this, and I want to just start with the comparison of the Indian market with the EU and the UK market. I think over here, again, I think Tilottama happens to be the person who will start the discussion. Tilottama, what do you think of the just a general approach to ex-ante regulations, right? I mean, how does the bill compare to the EU and the UK bill? Feel free to sort of take one approach or the other, maybe if you want to say on the UK or the EU, or if you want to sort of look at both, but is it really regulating ex-ante, right? So just sort of wanted to get your points on this, and just generally on the Indian market, have we been able to make sure that we are specific to the Indian market? So over to you.
To be very honest, I think we've played it safe. Okay, in the sense that, yes, we have examined practices and laws all over the world. And it is commendable, of course, in the sense that it's a very detailed document and it explores the need for ex-ante, which I tried to point out. We could be having these discussions on practical implementation, but theoretically, digital markets are very, very difficult to regulate. They definitely differ from traditional markets. To that extent, I feel we do need ex-ante. But coming and I was also looking at the questions in the chat box. I mean, there are.
But do you think the bill takes care of that? Bill is true to the philosophy of ex-ante.
See, like was discussed by the other panelist, ex-ante in the sense that we do identify certain practices, and then there's a presumption that these, so if you're designated as a dominant player, then these practices, these are the obligations cast on you. So to that extent, I mean, you can also call it imposing different thresholds like you do for AOD, honestly, for dominant companies in the digital sector. So in that sense, it need not really be ex-ante. You put a different threshold and then you start the examinations ex post, as was discussed. But having said that, at least you are designating some companies and asking them to be careful of certain activities. It is a starting point. Now, if you look at the law, I would still say it's a mix of the European and the UK approach, in the sense that we have these designated dominant entities, SSDs, and you also have a set of these practices. But again, those practices, you have left a lot of discretion to the CCI. For example, if you take each particular practice due to constraints of time, and other speakers will also have inputs, I'm not going into detail. Every CDS, the CCI has the power to go and evaluate it. So in that sense, I found it to be slightly similar to other jurisdictions like UK, where a lot of these, activities, sector specific, would be weighed by the authority. So in that sense, I see it's a mix. It's not fully ex ante. But having said that, at this stage, what else can be envisaged? The other option would be leaving it completely exposed, which would also pose a lot of problems. And another point I'm trying to make here is that if you look at the CCI orders passed in most of the cases, there is significant lack of clarity both with the regulator and with the players in the market. So when we speak of consultation with stakeholders, that should have been given more importance too, also because of the fact that none of us are fully aware. So even the companies, they've had a lot to say, but in other jurisdictions, first of all, they are more informed about the law in itself, which we are not. Now we are looking at a digital competition law. So I would say, given the circumstances, what we have today is a great starting point, undoubtedly with a lot of work given to the CCI in terms of regulations. And we have to see how those rules pan out. I mean, what do you take into account to designate something as anti-competitive tying or a coercive advertisement? Okay. What the factors which the CCI or these regulations would take into account, we have to see that. So as of now, it's a mix. And I would again say that, we've done a good study, but we've kind of played it safe. So we have to see how it pans out.
Kashish, what's your take on this?
My take is simple. you can call Digital Competition Act, the bill, the proposed bill, ex ante, in so much as you would call the Companies Act 2013 ex ante. Like what you have done is you have made
Do you think
obligations.
it's not truly ex ante,
Like
compared to the
it's
Europeans?
like, for example, why I would say Companies Act, right? You have director duties established under the Companies Act under Section 166, if I remember correctly. Then you have SEBI regulations that govern corporate governance principles of listed entities, etc. You have defined certain principles that directors, etc., must comply with. If that doesn't happen, you go to NCLT. That's the general process.
Yeah.
The DCA is doing a similar thing. You have defined obligations. If you don't do it, we'll do an investigation. So if you're calling it ex ante, I'm not sure if this is as like this is the I would say if you are to make an ex ante regulation, the idea is to make CCI's capacity, like increase CCI's capacities to do like if that is the question that you were hunting for to answer to find an answer for that, the response is something else, not this bill. Like you have to probably empower CCI to do way more consultations, come up with remedies basis those consultations. You already have a tool at disposal, like in terms of the market studies that you do. Probably there's an answer there. But if the answer if what you were looking for was ex ante regulation of competition in the market, this goes as far as, like, you would say Companies Act goes as far as to regulate companies and their corporate governance.
Deeksha, would love to get your inputs on this, especially, I mean, just looking at the Indian context and comparing it with the European context, but just, yeah, your early thoughts on this point.
Yeah, I think two parts probably in which I would want to look at it. I am still not convinced about the need for any form of ex-ante regulation. I'm still struggling to see it. And I've tried to read up quite a bit on whatever other people have been saying about this. But what I feel is that we are probably being driven more by fear and paranoia than empirical evidence. And I think there's a lot of FOMO element involved in all of this as well. So somebody's done it and everybody wants to do it. I'm failing to see the empirical reason for why ex-ante is needed. And then I completely agree with what Kashish said. This is not ex-ante. I think what this act does is two things. It does away with the requirement to define relevant market and dominance. One, not entirely dominance, actually, it just does away with the requirement to define relevant market. Secondly, it just inverses the burden of proof. Typically, you would have, for any activity, you would have the CCI and the DG required to demonstrate infringement, or a complainant required to demonstrate it prima facie. In this case, I'm submitting my compliance report to you, and I have the burden to show to you that I'm compliant. So I think these are the only two things that this bill is achieving. Insofar as the 6 ACPs are concerned, I think they could have been added as explanations to Section 4, and it would have been all fine. So I don't really see any ex-ante element here.
Just on that point, do you think it will help in reducing the number of time for final adjudication? Because that was something which was one of the concerning factor for the CCI to say, okay, look, it takes a lot of time, and then by then the harm is already done, right? So will this bill really sort of reduce that time? And everyone just can come in on this.
I don't think significantly. Maybe a little bit, but not significantly, because as I was explaining earlier, I think the processes within the Competition Act have now been placed at different levels, but the same processes will be carried out, but they'll be at different stages. So you will designate me as a dominant entity first, or an SSD, then later on at some point of time, you'll examine my conduct. So it's all spaced out. So I don't think it changes really the time for you to be able to react and remedy the market. And again, it's going back to probably what we might be covering towards the end of the session as well. If not this, then what? I think that depends on identifying the problem statement. If the problem statement, which I agree with you, Kazim, from the report, it seems to be investigation is taking a long time. I think then the solution is you've just come out with settlement and commitments that can those help? You have Section 33, which allow you to pass interim orders. Should you be using those more? So at least once the investigation is started, you've passed something which prevents the market from getting spoiled more. Third is, should you be strengthening the procedural architecture of the commission so that people are not filing that many writ petitions? I know because I have filed writ petitions against RFIs that Kashish mentioned. So if you know, you'd had protocols like EU has Reg 1 of 2003, fairly detailed. Come up with something like that, reduce chances of procedural challenges. And in any event, when I started practicing competition law, 2011, you would go to the High Court, you would get a stay at a drop of a hat. High Courts have become really smart and discerning now. So it's not the same thing, right? So you're building up the regulatory architecture within the CCI. Fourth could be to build up the courts to be able to deal with these kind of challenges. And fifth would be to build up capacity within the CCI to increase generally the speed of the investigation. So I think maybe a combination of those five and I like Kashish's idea of more robust market studies. Our market studies are fairly toothless compared to what happens in UK, where basically remedies can be passed after market studies. So we are in a different zone, but maybe more market studies could also help.
Interesting. I have two hands raised. Kashish, you want to come in quickly? Because
can I just come in before?
Yeah.
So I will not say anything about the UK. I can't say that. But what I would say is I definitely agree with Deeksha's points on capacity building and creating the infrastructure around litigation. There's so much to be done there. Especially like I would agree specifically on the part of interim orders. Like the CCI, and that's probably a larger comment on like quasi-judicial regulators in India. They were created to escape the rigors that are applicable on courts in deciding and passing remedies or like passing interim orders, for example, even a simple thing as an interim order. But what ends up happening is because their members are judges, ex-judges, or like people who have been in the government, they end up following the same rigors that a court does. The CCI's standard for an interim order is the American Cyanamide and then the sale standard, the sale decision standard, which is what a court would do as well. You don't need as high standards for interim orders. Probably there is something to be done there, and that would make investigations more robust. That would make the impact of Competition Act more robust. Like, why do you need to have such archaic rules on interim orders, for example? That is something that I would 100% say is needs correction if you have to look at within the competition law framework in India.
So Tilottama, if we all think that the problem is that there is not enough capacity within the CCI and there are procedural issues which we need to strengthen, then why need this bill, right? I mean, what is it really solving? What do you think on that?
Honestly, if you ask me, one major problem has been with the fact that with the existing Competition Act, we could not find any entity for abuse of dominance simply because we did not know what would be dominance in the digital space. So there were many practices which the CCI looked at, but because they couldn't find dominance, cases could not be decided. So here I tend to agree with the other panelists. If nothing, at least it saves us from trying to prove what is a dominant entity because you have those designated entities already. Now, the larger question is that could this be done by adding to Section 4? Or did you need a law which added so many more complications along with it, keeping in mind the constraints? Now, that is something I don't have an answer to, but I think we've all by and large understood that, it's not really ex-ante in that sense. But the one way, I mean, at least it seems to me, is that looking at the number of cases where the CCI has expressly, has said that I cannot decide on this, I cannot decide on dominance, at least this would help with that. Okay, there would be cases where you don't have to prove this. Now, having said that, interim injunctions is something I put my hand up then, but Kashish has already covered that. In fact, we had written a paper on this about 2 years back, saying that this would be more of an effective solution, and this is such an unused power. Let's give it, more importance, because if you are not sure about the way a practice is going to pan out and you don't want to hurt the market, you want to encourage innovation, this would be a good step forward. But that has not been looked into. This is I completely agree with Kashish and Deeksha here. This is a very good power in the hands of the CCI. Now, regarding this particular legislation, yes, this is my thought. At least it would help in designating what is a dominant entity. To that extent, yes.
To that extent itself, it's good enough. But what about the other aspects? So I think those are all moot points. I think we have around, okay, we are at 7:15, so we don't have enough time. So very quickly, I think I'll skip the capacity question, which I think has already been covered by all the panelists. I think we all agree there is need for greater capacity, and maybe that will solve most of the issues which are of concern in nature of what's potential anti-competitive harms in the digital market, instead of coming up with a new bill. But I want to sort of go on the consultation process. And this is something which, we've been looking at in India. We were provided 1 month, I think 1.5 months time for the bill, and we've been given another 1 month extension. But if you look at when this really started, this started when the CLRC committee report, and then of course the parliamentary committee report really kicked this conversation in late 2022. So we are possibly in the third year of debating and discussing a potential ex-ante regulation. Kashish, I want to just come to you first in terms of the process. It was adopted in the UK. You may not comment on UK, but in the EU, the process time was much longer, right? Diksha also pointed out that there were open house consultations where people could come in and comment. And do you think the consultation period in India is the time sufficient? Do you need more time? Do you need more discussions with the government? Should we have briefing sessions? Should we allow for some Q&A sessions before we really take the bill to the parliament? So over to you.
I think the key is, I don't know if I would say anything on the time element of it specifically. The idea is consultation should be effective, and that is like what ends up like mattering in these processes. I like, for me, when I saw the report, it has a section on what the different stakeholders said and what were their comments on different issues, and like the discussions have already been done at the time of report as well. My 2 cents is only that if the industry doesn't think this time is is good enough for an effective consultation, probably have more. But the idea is the consultation should be effective.
Yeah, fair enough. Deeksha.
Yeah, I would generally agree with Kashish. I think this government has generally become a lot better in terms of consultation. There's a general move towards adopting a consultative process. So that's a good, but do we need more time? Possibly, yes, because a lot of intricate issues are raised here. But I think for DCA, once it becomes a law, consultation is going to be something which is going to be the lifeline for the regulator. So it will have to be something which is inbuilt into the DNA of the act itself. So maybe if they had come up with a similar section as they did in the Competition Act's recent amendment, necessarily requiring public consultation for everything, that would have also been great, just to, build that consultation into the DNA of the act.
Tilottama, any final points on this before we open for questions?
Nothing much, excepting to say that, generally what we have observed, particularly, and I'm not just talking of large companies here, newer companies, is that there is and this is something which we've seen even in, conferences, etc., where the industry engages, there is a lot of mistrust. Because like I said before, they are not, the Competition Act itself was a very new law suddenly imposed on the industry. So consultations are very important, and I think to get rid of this feeling of mistrust, Also because, like I said, it's been a very new law which was suddenly imposed, and even basic concepts like cartels were not really known. And even today, people are very unclear about what is collaborative bidding and what is not. So I think first there should be awareness, trust, then consultation, because I think we need to start at the very basics of it. And this is going to be, I don't see it as a very simple exercise.
Yep.
And I really don't know. And I completely agree with the fact that, yes, it has to be, it doesn't matter how long it takes, accepting it has to be effective. So yes, that is very, very important, that to see that the consultations are effective. And I'm not very sure about how long that could take, or whether we learn lessons on the way. We'll see more, the way the world operates, you'll have more and more, let's say, famous cases being decided, and people take a cue, they become aware. But for effective consultation, particularly in the Indian climate with our mindsets, it's going to take some time to get rid of this these trust issues. Yeah.
I just want to add that in the entire data protection process, I think enacting the Data Protection Act, I think there was a 6-year process, multiple iterations of the bill, and there was a parliamentary committee, of course, which looked into it, similar to what the Finance Committee had done with digital markets. And we saw the law 6 years after the Supreme Court's judgment. There was a very extensive consultation process, multiple iterations, multiple bills coming in, and the new versions coming in as well. Wide variety of stakeholders were consulted. And if you look at the digital markets bill, I think we are sort of looking at this draft, which is possibly the first draft. So, I mean, you provided 6 years when it comes to Data Protection Act. In my opinion, this is going to have a much wider impact on the ecosystem, on the digital markets and non-digital, non-tech market as well. Providing a 6-month or even an 8-month period will not be enough. I think it would necessitate at least 2 to 3 years, if not more, before we sort of see the light of the bill and we see the bill getting enacted. But I do feel that we need a lot more time to just study the bill and allow the stakeholders to understand and interpret it in terms of the impact it could have currently and in the future on both the Indian ecosystem and just the sort of the nature of investments we have and how Indian market will be a viable market for future investments. Because unlike the European market, there exists a very strong local enterprise ecosystem in India, which was not the case in Europe, and which is where it required them to protect their own market to come up with the Digital Markets Act, which is why I think the Indian market realities are quite different. So maybe we need a sort of a different approach as well when it comes to the bill, and just the entire consideration process should consider these points as we proceed ahead. But thanks a lot to all the panelists for this very engaging discussion. We have a few questions coming in. We have around 10 minutes, 5 to 10 minutes for Q&A. There are a few questions which have been asked on the chat box. So I'm going to start with those first, and then we will ask others to just keep dropping in. So if those who have stayed back, please drop in questions. Feel free to write in, and we'll sort of take it. We'll start with Ria, and she has 2 questions. Partha has also made an observation. I'll start with Ria very quickly, and anybody can take this. So I quote, despite a vocal lobby, including Digital News Publishers Association and Newspaper Association, aggregators are not listed in the schedule as an online intermediation service, even though the CCI has started investigations into ACPs by Google, etc. What do you think the bill has? Why do you think the bill has excluded the category, despite the standing committee explicitly recommending regulation along the lines of the Australia's bargaining code? Is this exclusion a good thing, given that some commentators believe that this should be left to intellectual property law and not competition law? So whoever wants to take this can come in.
I think very quickly I can probably take this. I think online intermediation service has been defined rather broadly, inclusively. So it is something that could be fixed in there. But from my understanding of the News Publisher Association cases, I think the problem as far as the 26(1) from the CCI indicates is with respect to the search services and ads. So it's sort of
Mhm.
lying in those buckets. So I think this particular instance would fall there, but more generally, I think news aggregation might get covered in online intermediation
Mhm.
services because it's fairly broadly worded. So probably it could get covered there.
I think I
Fair
would
enough.
just add that I am on the side of the debate on this, where I believe it's not a competition law burden. I think it's one of those things where copyright law has just not kept up to the mark. Like that's the same issue that New York Times is facing in New York on ChatGPT. So that it's the same idea. Copyright law needs
Mhm.
to catch up as well. It's you can't just expect all of the burdens to be carried by competition law.
Fair enough. Okay, second question is on the justification for the government exemption power under Section 38 is just the fact that the section is analogous to Section 54 of the 2002 Act, which is not a reasoned rationale per se. What is your projection on how much of an issue will this become, given that the government and its PSUs are greatly involved in several CDS? For example, IRCTC will it be excluded from regulation while all other travel aggregators are not? Interesting question. Who wants to take this up? Tilottama, you want to come in? Or Deeksha, you want to take it up?
See, I mean, as far as I would, without commenting on the specifics of why this was done,
Mhm.
central government, yeah, there are dangers. Of course, there are. But then it is not something which is not open to challenge. So if something is done which somebody feels aggrieved with, that is already that is open to challenge. So that
Mhm.
would be, without going into specifics of why this particular action was taken, that is what I would say. Because mm, when I'm looking at the question once more in the sense that the section is not a reasoned. So like I said before, this is something we've had to deal with in many other laws. There may
Mm.
not be clear justifications, but if there are dangers to it, there are certain dangers, yes, but they are not something which cannot be challenged.
Fair enough.
Just very
Okay.
quickly coming in
Yeah.
there, I, I
Mhm.
I think the vires of the section, similar to 54, can be challenged. There's a good reason to challenge the vires on a constitutional basis. Has not been done. Happy for one of the students here to pick it up and challenge it. But on the dangers of it, I agree with Tilottama. If something really happens of this nature, where, for instance, IRCTC is completely excluded despite meeting
Mm.
all the criteria, unless we see a good reason and rationale in the government order passed under 38 doing that, that order itself, that notification itself will be subject to judicial review. So this will be a case by case remediation process, but a more broader challenge can also be
Mhm.
filed. I haven't examined how successful we will be in that challenge, but I do see a preliminary reason for why the vires can be challenged.
I think the broader concern,
I
which I think the students are, oh, sorry, Kashish, yeah, come
no, sorry, you please go on, and
in.
then
No,
I can add.
so
Oh, I
basically,
was
I
just
think that,
gonna,
yeah,
sorry,
after you.
yeah. Also, I was just going to recommend that if it's not just going to be IRCTC, I think one
Mm.
of the concerns that I could read behind why such a provision would exist is to protect institutions such as NPCI, like the National
Mm.
Payments Corporation of India. UPI is one of the government's like hallmark projects, and that is a monopoly sort of. So I don't know. Uh,
Yeah,
and probably that is also an area, like it's not just IRCTC. If someone wants to write something, research something, or challenge something, that's also some place where you could look up.
right. Yeah, I think just the broader concern is what about government services, those who will be dominant within this act, right? I mean, those services which qualify within the CDS category, and those could be SSDs. What about them, right? So will government exempt its own entities? I think that's generally something which we've seen in the different acts as well in India, that concern remains, but I think let's see how it plays out. And yeah, if this is something which becomes an issue, I'm definitely sure it will be taken up at the courts. So yeah, so Partha's question is there could still be competition concerns if there was an exchange of historic, competitively sensitive non-public information during the development of the algorithm, even if no such data were further supplied during the life phase of the algorithm being used to recommend set prices. How do the panelists view this from a practical monitoring and enforcement perspective without being an overkill? Whoever wants to take this up.
I don't know if
Deeksha?
Kashish, you've had any experience with algorithmic collusion, but it is a difficult thing to monitor. But that said, I agree with Partha at a very theoretical level. There is a concern if data is being given even to train the AI, because an AI is going to use that data. So it's not like it's just data given in the training phase, so it doesn't really impact the life phase. I think there could be a case of algorithmic collusion made out here, depending on what is the kind of data that has been fed to the AI and for what purpose, and in the life phase, what is the algorithm doing. If this all remains, which I'm sure is not what Partha's meant, if this all remains data of only one company, there's no concern, right? I develop an AI user within my company, no issue. But if this data is then widely distributed as a product to competitors, this could be a concern. How would you monitor it and enforce it? I think this is one area where probably we need to see how much regulatory capacities in this aspect also develop, and how AI regulation generally develops. I'm sorry, Partha, I don't have a ready answer on how do you monitor and enforce this aspect, because I think algorithmic collusion is going to be something which might be a little tricky unless it's a clear-cut case of company X being asked to manufacture an algorithm for 5 competitors. I think that one might be an easier one to crack. But otherwise, I think use of algorithms for price collusion will be a little difficult to monitor and enforce.
And also to add to that, I'm very happy to get this question in the sense there are a lot of overlapping issues, overlaps with other sectors, which also haven't been very clearly addressed. Like a question like this, algorithmic collusion is something we're not very clear about, but there are various points of intersection with other laws. And how is that going to be worked out? How are these overlaps going to be addressed? That also remains to be seen. So data is a question, advertising is another question. So there are several of these areas.
Fair enough. Very quickly, final question from Vashisht. How inclusive could this bill be with respect to anti-competitive issues in the labor market, considering the skill factor of an employee being an essential part of providing CDS? Kashish, you want to comment on this?
I think this bill is not, I'm not sure if that is going to be the place for labor practices and competition law like issues, because this would remain focused on the CDSs and how companies interact with each other with respect to those CDSs and how companies interact with consumers in respect of those CDSs. I think classic competition law is still there to tackle those issues. I mean, maybe practitioners can weigh in here.
Tilottama, you have your hand raised.
Yeah.
Okay. Deeksha, Tilottama, anyone wants to take a final stab at this?
The final question or the labor market?
The labor market.
Labor market, I think, one of the points I made initially was that we don't know how these ACPs have been identified, right? They seem to me to be driven by the issues that the Commission is also currently facing. I think labor markets as an issue hasn't really blown up in India the way it has outside. But also, I think the traditional, as Kashish was saying, the traditional competition law, the Competition Act and Section 3, I think would be adequate to deal with it. So I don't know if it was specifically required here. Could we add in a requirement to say that you will not enter into agreement with your competitors about employees and fixed remuneration of employees? Yes, I mean, this bill is almost like thou shall not steal. So we could have added one more testament there, but I think this is something that can be well dealt with within the scope of traditional competition law.
And thou should tell us that thou shalt not steal.
Yes, thou hast to demonstrate that thou shalt not
Demonstrate.
steal.
Because that's the only way we can monitor that you're not gonna steal, right? So fair enough. I think there's one last question by an anonymous attendee. And I read on the point of need of this law, what problems will this law in relation to digital services serve to correct? And is there any change in the provisions in relation to the previous Competition Act 2002, like any new anti-competitive conduct being added on for the digital service, or we have the same wrongful conducts? Also, like there are these network effects, okay, somebody's brought this up, which plays a huge role while assessing dominance in the digital sector, and those are not visible on their primary stage, but are only visible after some time. So do you think the practice of designation of dominance ex ante would really be helpful? Interesting question. I think alludes to most of the philosophy which we've been discussing, but who wants to take this up?
Okay,
Tilottama?
so I'll just add the last part of the question is the chicken and egg problem, which we are grappling with and the world has been grappling with. So honestly, that, you know, the network effects which play a huge role while assessing dominance digital sector not visible in their primary stage, we could have a very lengthy discussion on network effects and the need to
Yes.
regulate them.
Yeah.
So I don't think we can, I mean, without going into a lot of detail, we have to see how it plays out, because this is something we really have no clarity on as of now. So, and the rest of it, I feel we've already discussed in, you
Yeah.
know, in the course of our discussions. So network effects is something we can't give any clear answer to. I mean, that's the entire crux on which we have these debates about ex post and ex ante regulations. So, so it's the
I
only
just
thing.
want to add,
Hmm.
sorry, Tilottama. Yeah, no.
No,
I
go
thought
on,
you
go
were
on, go
concluding.
on, go on.
No, I just want to add that, and there is no evidence, I mean, there is evidence, but there is no conclusion that network effects are per se negative. Like there are positive pro-competitive aspects of network
Absolutely,
effects as
because
well. So if you want to debate, and I mean, this is a great debate, and I would urge NLS to maybe follow up with something on these lines, because in general, there is a sentiment that network effects are evil in nature and they are causing a lot of harm. But I think when it comes to the downstream businesses and the downstream players, there is tremendous value which they bring when it comes to the possibility of small businesses to prosper on these networks. Otherwise, you've seen the pre-tech economy when these digital network effects were not in place. The entire ecosystem was very different. The potential these network effects bring in for different businesses, small businesses, even people who have ideas. You're looking at platforms like YouTube, which basically is giving space for so many different types of content creators. So in a way, and if we look back 20 years or 15 years, if you go back in time, let's just look at broadcasting particularly. Let's look at media, and there were few channels, there were few people, content creators who were sort of dominating through and throughout. With internet, democratization took place, which led to the creation of network effects. So it did break a monopoly. Has it created another monopoly is a moot point. But sorry, Tilottama, you were finishing something.
I just want to say, I mean, the focus of it, and this remains the problem, no matter how much we debate on how we enforce it. Of course, enforcement is the practical reality, but the focus is we should not curb innovation. We should not curb newer markets. So, which is why when I say there is no straightforward answer, because the dangers of over-regulation are often greater.
Yeah.
So that's how I would like to put it. The object
Yeah.
should be to encourage newer markets, encourage innovation.
Yeah.
Yeah.
Fair enough. I think we'll have to conclude. I think we're just above time, way above time. I think we would have to conclude the session. Thank you so much to all the panelists, to the students who've been around. And it's been a pleasure to sort of have the discussion. And Chinjoy, over to you.
Yes, so the joint convener Khushi will deliver the vote of thanks, and thank you all for joining in.
Thank you.
So thanks a lot to all the panelists for finding time and agreeing to be a part of this panel discussion. It had been a really insightful panel discussion, and I would also like to thank Kazim sir for moderating this session in such a great manner. We really look forward to connecting with the panelists and the moderator in future for similar conversation around tech regulation, and we hope to conduct more such sessions in future.
Thank you.
Thank you all. And
Thanks a
so
lot.
the attendees can start leaving. I think we come to the end of this discussion.